Ladies and gentlemen, our members and guests connected with us this morning, good morning. This is our third day with the plenary dealing with decision-making standardization in industrial property in court.
A certeza do direito espelha a capacidade das leis de conferirem ao cidadão entendimento quanto ao que é justo frente ao direito, enquanto a segurança jurídica reflete a confiança que se pode ter na eficiente e justa aplicação das leis. Ambos são atributos importantes para o desenvolvimento econômico e social de um país e estão interrelacionados. Quanto mais certeza do direito houver, mais
The more certainty about the law, more legal security you offer to citizens. And the more you have that, the less complicated it's going to be to sign contracts. There's going to be less cost in transaction, and there will be more incentives to investments. In addition to law quality, the various ways of enforcing the law and consolidating case law are critical for legal security. In terms of intellectual property, the challenge is great in this sense. It is very important to foster innovation and promote development. This plenary is going to have Isabel Gomes, Flavia Romanes, and Manuela Pereira Calves. The three of them are justices, making their comments about these issues and discuss the future. Jacques Labruni is a director, member of the board of ABPI. Before I give the floor to the moderator, we just welcome our president who came here to give you his warm welcome. Good morning, everyone. I'd like to take the opportunity, I'm here, to welcome our speakers. ABPI feels honored with their participation. And I'd like to say that we have over 1,200 participants watching our Congress. This is a great number to us. I'd like to take the opportunity to say that in our first speech, we had the honor to welcome Humberto Martins from the Higher Court of Justice, who made comments and focused on judges and court specialization. ABPI has been working very hard to get to this, especially the Court of Appeals of the state of Rio de Janeiro. Today, we're going to hear three justices. Two of them already work in special courts. Justice Flavia Rezende, she's still not in a special court because it's not available in the Court of Appeals of the state of Israel, but ABPI next year, next year, we're going to focus on making some courts special courts. And we hope that Justice Flavia Rezende will come along. I am then returning the floor. In fact, giving the floor to Counsel Jacques Labruni. Counsel, good morning, Erica. We had a little audio challenge. We didn't hear all the comments from our chairman. And we had some challenges with mics here. Some of the mics seem to be off, but we still hear them. But now I believe all the technical problems have been solved. Thank you so much, Erica. Good morning, everyone. It's a great pleasure. Although we had a little technical problem, unfortunately, we missed some of the comments from Chairman Luis Edgar, but on behalf of ABPI, it is a great pleasure to begin this plenary session. As our chairman mentioned when we could still hear him, we have 1,200 participants in this very special moment in time in this country where we are forced to be in social distancing. It's a shame we cannot meet each other physically as we did in the 39 previous Congress, and we hope we will next time be well protected and vaccinated so we can still have the social and dear contact. It is a great pleasure for ABPI, despite the difficulties, to be part of this event, and specifically in this plenary, as the video has introduced. So then the moderator doesn't have to define the topic in question. What the video showed is that legal security is critical to the development of our country, and our court system has been working hard in this sense to improve this country. We have so much social inequality, so many differences, and poverty. So these are opportunities for more investments in health services, education, so that we can grow and have Brazilian citizens to become happier and with their development opportunities protected. Today, 3 members of 3 courts, I would say, the 3 most relevant higher courts for industrial property in Rio de Janeiro and in the state of Sao Paulo, in the state courts of appeal, we have the highest number of cases of industrial property violations. As both the Court of Appeals of the states of Rio de Janeiro and Sao Paulo dealing with the most numbers of industrial intellectual property violations, and the second region federal Court of Appeals is the one dealing with the validity or non-validity of rights relating to the Brazilian PTO, correcting decisions of the BRPTO. And so anything to do with the Brazilian PTO is up to the Federal Court of Appeals. Although the Brazilian PTO is in Rio de Janeiro, it is the Federal Court of Appeals in Brasilia that deals with these issues. So these 3 courts are special courts when it comes to industrial property. Today, in the Court of Appeals of the state of Rio de Janeiro, it's not special court yet. In Sao Paulo, we have 2 special corporate courts. And then we also have 2 panels at the Federal Court of Appeals specialized in industrial property. So it is a great pleasure to have their perspectives, long experienced representatives to talk about these topics. I am going to make a brief presentation of our 3 speakers so that they can get the floor to make their presentations without interruption. Starting with Justice Manuel Pereira Calças, who kindly told us he is going to be absent during this plenary because he is leading a session today, but he made the effort to be around. But before I introduce them, I'd like to thank them profoundly for the presence of the 3 justices that kindly accepted the invitation without any compensation, bringing their experiences and their concerns on industrial property for the development of the country. So Justice Manuel Pereira Calças is a justice of the state of São Paulo Court of Appeals. He has been president there. He is the president of the special courts group, and is one of the people behind these courts, special courts. There was one that was launched in 2011, and he was in the launch, he was speaking there. So he is in fact a fan and a disseminator of special courts. He's a professor of corporate law at the University of São Paulo. He was a professor at the Catholic University of São Paulo. We have been together there, and it is a great pleasure to introduce Justice Calças. Next, we're going to have Justice Flavia Romano, who is a higher judge at the Rio de Janeiro State Court of Appeals. She is a chairperson of a tax board of energy. She is highly experienced in also industrial property. She has been a counsel in this area in Coca-Cola, representing the Coca-Cola trademark, which is one of the most well-known in the world. She's worked in Atlanta, and she was a legal counsel at Coca-Cola. And as a counsel, she also did practice in this area. Thank you so much for your participation in this Congress once more. And also a well-known figure to all of us, as the other two, Justice Abel Gomes, Justice of the Federal Court of Appeals of the Second Region, and he's a member of the second panel, special panel that has been judging industrial property topics in addition to criminal law. He has abandoned us recently because he was overwhelmed for obvious reasons, and we thank you so much for your adequate decisions in upon politicians in the city and state of Rio de Janeiro. He has a degree in law from the University of State of Rio de Janeiro, and he has been working in this special panel with incredible opinions, examining, entertaining issues, not only in trademarks, but also in patents for medication, as well as agricultural products. And he has participated in a number of events, always conferring his brilliant ideas to industrial property. You have helped us in disseminating issues around industrial property. So without further ado, I am going to move on and give the floor to Justice Calças for his presentation. Thank you so much, Justice Calças. The English translation booth apologizes. Apparently, we're having an issue with microphones. Can you hear me? Yes. Go ahead, sir. I was actually apologizing for this technical glitch we had here. I was working with the University of São Paulo, and my microphone was working well. I could see you from here perfectly, but I couldn't talk to you. But fortunately, we managed to solve this technical issue. So first of all, good morning, everyone. I am here in São José do Rio Preto, in the interior of São Paulo, one of the places where I live. where I worked for 12 years, and then I have part of my library and part of my home in this town. Secondly, I'd like to say it's a great honor to be here among three incredibly experienced colleagues, Justice Plaza Vigenti and Justice Abel. I have known them for their work and for their different works, and I am a big fan of both of them. Although we're only in technology contact, I hope we are going to meet physically soon. It's a great pleasure to be next to two such relevant people for the legal life of this country. Counsel Labrini, I have known for over 30 years in counseling, in various activities. I cannot stress enough the admiration and respect I have towards him. Counsel Jacques Labrini, I have 20 minutes, right? Yes, correct. Well, first of all, it's a great honor to be part of this international congress, ABPI International Congress. Without a doubt, the most relevant event when it comes to intellectual property in Brazil. I would like to greet all participants, not just in number, but also in quality. Those who dedicate their lives to the study of such relevant matter. A topic I practice on a daily basis in my business life. I accepted the invitation. Although I have been a professor in intellectual, more like industrial property, trademarks and patents. In fact, I was more dealing with the old law in bankruptcy and restructuring. As a counsel, Jacques Labrini mentioned, I worked at the Catholic University of São Paulo for many years. I do work on a daily basis, and believe it or not, we deal, the most cases we deal with is industrial property. And then I'll explain why this has scared me in a good sense, because I could never imagine that the number of litigations that exist in industrial property and what is under the competence of the state level courts. I have been working for 45 years. In practice, I would never imagine that industrial property litigation would overcome corporate litigation, and it is a fact. And I can say this without a doubt after so many years of experience. As Professor Jacques Labrini has mentioned, I did prepare industrial property topics that we deal with in our corporate courts. But when I spoke to Professor Labrini, and he is our conductor this morning, I apologize, not this evening, this morning. he said, I would like you to talk about your long experience when it comes to the creation of special courts. So with this great invitation, I was also invited to talk about the same topic by Professor Alfredo Assis Gonçalves to speak in the state of Paraná to talk about special courts. I also spoke about this matter and the Rio de Janeiro State Court of Appeals precisely about the same topic. I have a number of friends at the Rio de Janeiro State Court of Appeals. So I'm not going to speak about industrial property instead of, I prefer to use this term because I don't work so much with copyrights. Here in São Paulo, copyrights is under private law and not corporate law. Still, first and 10th court of private law, even though there's a movement to bring them to corporate court, law courts. We work with industrial property more in unfair competition as well as patents and trademarks. So I am going to then stick to what was asked of me to say that I am here on behalf of corporate court group. I am a chairman there after I left the presidency of the court as today we call them reserved courts. As we have counsels, professors, judges, and members of the prosecution office from all states of Brazil. So special courts is a relevant topic for everyone, be it the federal sphere or the state sphere. So this is an effort I have been taking part in since 2005. I'd like to thank on behalf of the state of São Paulo Court of Appeals, but I'm speaking on behalf of the reserved corporate law courts group. I am a personal participant in the court that used to be originally called Special Court of Corporate Restructuring and Bankruptcy, created on the 9th of June, 2005. And I apologize for the repetition. When a law was enacted to replace the 7661 decree, the old bankruptcy law at the time, under the guidance of the World Bank, São Paulo was forced, between quotation marks, to have a special court for bankruptcy and corporate restructuring to follow global guidelines at the time, because the state of São Paulo, because of the number of cases, the sheer number of cases, was not having any influence on the Superior Court of Justice in case law for the higher courts courts to reinforce the competence of the higher court over national case law in terms of the bankruptcy and corporate restructuring law. So the new law, after 15 years enacted, there's been a pressure so that São Paulo would have a special court in order to increase efficiency, as because of the sheer volume of court cases in São Paulo, when judgments of appeals case law in the higher court would have been consolidated for bankruptcy and corporate restructuring. As case law helped consolidate the higher courts, and then São Paulo was not contributing so much for case law in Brazil. At the time, justices participated, at the time, Justice Sidney Benetti and late Justice Sávio Figueiredo, that had a great participation in the process. I was the young boy at the time, so we all participated in creating this chamber. And in 2005, we initiated the reserved court, and the first special courts specialized in bankruptcy and corporate restructuring, all to comply with Law 11-101 from 2005, with the help of the Brazilian Bar Association, the Institute of Legal Counsel in São Paulo, and other institutions, as well as the Catholic University of São Paulo, as well as the University of São Paulo. So this was a first experience, because Rio de Janeiro, #1 in special courts, as everybody knows, because in 1885, Rio de Janeiro was #1 at the time, because we used to have the old imperial corporate court at the time. So this already started at trial court level, specialized courts on lower court level, especially in corporate restructuring and bankruptcy. Lawyers welcomed the initiative and also welcomed the results of such initiative. We had some problems to issue the necessary precedent decisions to comply with Law 11-101 of 2005, because we needed to form groups to approve the precedent decisions. So we had to form groups that were formed for various high court justices that had never enforced the 11-101 Act, because they were still linked to the decree, the old decree. And the changes were enormous in terms of bankruptcy. And it also impacted on corporate restructuring, because they lost certain characteristics. So this is what happened in a nutshell. So in 2011, we decided to create what was called at the time the only corporate court at the time. We were part of this movement with the support of all the institutions I have just mentioned. And we also created Resolution 538, creating the first only reserved corporate law court. And it dealt with now coming into intellectual property. Also, the private initiative protected by the Civil Code, which was inserted by according to Professor Marconi, which is called a business activity. So this is the free private initiative. In the old imperial law of an article of the old imperial code of 1850, taking a number of articles of the current civil code, starting with the concept of a business person. The private initiative law contemplates the corporate law, the code for industrial property, and the whole Industrial Property Act, all the franchising issues, and conciliation and mediation related to industrial property.
All main actions, provisional measures derived from this legislation, this would be the subject matter which is under the responsibility of this chamber. It didn't last very long because due to initiatives of the members, and some of the appeals judge were member of both. And I remember that that I had a position in the Chamber of Bankruptcy and Restructuring, and also together with Judge Recupero, I was in the corporate chamber, and I was also responsible for private law because actually there were 3 chambers. And this was the ordinary private law. So we were overloaded with work because there was no compensation for that. So we understood that in order to reach decisions with the highest level of specialization quality, we decided that it would be best to unify the competences of these 2 specialized chambers. And Dr. Flavia, let me tell you what we did. We are going to get the bankruptcy and restructuring chamber and the corporate chamber, and we've united them both. So the first and the second chamber of corporate law were created. And that includes corporate recovery, bankruptcy, out-of-court recovery, and all the other connecting cases. Industrial property with all the provisional measures, arbitration, franchising, corporate law. So we were able to round up this chambers and have one corporate group. And this is what is taking place until today in general terms. So we have here in Sao Paulo a approach for states that are now beginning this process. And we face many problems, not only political problems, because of course, and with all due respect, there are always those who are against this specialization. But not only we had specialization at the trial level, in bankruptcy and corporate recovery, and at the appeals level. Dr. Jacques, we had already all corporate matter in place because both chambers were specialized. So we had, how could I qualify it? We had a whole structure at the appeals level. Well, I shouldn't say everything because some topics were left out. For example, commercial representative. This is something that has not been included. The law known as the Ferrari law has not been included. The criminal aspect, this is still being held at the criminal session. So I think we could further progress in this sense. But at the appeals level, we have this specialization structure as such. And what I see is a very significant volume in corporate law in general, and also in all the anticipated remedies that are very intense, especially when it comes to industrial property. This is certainly a lot of work. And if you work with industrial property, you know exactly what I'm talking about, and also in corporate law. Subsequently, well, I should mention before that a very relevant fact which took place. And this is something that Dr. Jacques reminded me, because when we were ready to start the reserved chamber for corporate law, when it was one only chamber, so this was before the merge, of course. At that point, I was appointed by the president of the court, Dr. Dubre, who was a great person, to speak on behalf of the Justice Court. And we have emphasized, and this was just mentioned when we started our panel, our plenary, Dr. Jacques has mentioned it. It was mentioned that one of the goals of specialization, especially involving issues such as unfair competition, trademarks, patents, corporate cases, licensing, franchising. And at that point, we stress that due to the global economy that prevailed already at that point, and this is a scenario in which international competence is very present, and it came to my mind the work of Dr. Flavia at the company Coca-Cola, because that means that companies are competing in a market where profit margins tend to be smaller and smaller. So at the time, we said that an environment with full legal security, with full foreseeability of decisions, what could business persons do to deal with uncertainties that derive from the judiciary power in a country like ours? We are a federation, and we have a vast territory. It's almost a continent. So the inevitable consequence is that prices will reflect, companies will have their prices reflecting the uncertainty of such divergent court decisions. And another inevitable consequence is the fact that products and services will have to bear the cost of this uncertainty, and which has an impact in inflation. So at that time, and Dr. Sachs was, he said he was there. He was there. We pointed out that corporate law and this specialization that we are talking here, this is a topic that is not included only in the particular area of interest of the business community. This is of interest to the whole society in Brazil and to economy. So legal security, having decisions that are foreseeable, the jurisdictional review, these are all factors that are going to heavily impact product and services prices. Another fact that I would like to remind you, given this opportunity that I have here, is that 2 or 3 days before we started this special court in Sao Paulo, I had a visit from two colleagues from the Catholic University, and they came to tell me that 4 or 5 days before the court was started, we started on June 30th. On the 24th of that year in Portugal, a law was sanctioned. It was the 42 2011. It created, this act in Portugal created a Portuguese specialized court in industrial property. It was exactly the same route that they were following. I didn't know, it was my colleague who told me about that. It was exactly a court devoted to industrial property. And I am about to conclude, but let me say that we have kept going in this path of specialization, and we had it at the trial level, then appeals level. In December 2017, at the internal affair units of our courts, we carried out a significant work, helped and assisted by the Brazilian Association of specialized in this matter, to help us, to support us in what we call a high level of viscosity, which is something that brings to those who work in the commercial area additional difficulties. Sometimes we are dealing with cases and we have the numbers and we have the circuit. Statistics are not enough. We had the support of the Statistics Bureau of São Paulo, but this association was highly supportive, and I want to recognize their work. And I think the other states are going to need their support. And we were able to have, at the time, at the head of this effort was Dr. Mascaretti, and we were able to start the first and second corporate circuit in São Paulo, devoted to corporate matters and contemplating arbitration. Also, we also included bankruptcy, restructure, and industrial property, in addition to the corporate law. So what we did at this point is that we entirely verticalize the specialized competence. And we had at the trial level, at the appeals level, which didn't exist before, such resources. Judges now could be specialized at the trial level, and we've chosen judges that were highly qualified with a master's degree and a doctor's degree in commercial law, especially in the area of intellectual property and industrial property, so that we could have qualified individuals to decide in the safest, effective, and expedite way. So as I said, we had at the trial level and at the appeals level a specialized body. So the trend is that we will keep improving more and more, not only in corporate law. And these judges are not in the area of bankruptcy and recovery. Just to clarify, especially to other states. So in Sao Paulo, we have 3 specialized circuits at the trial level: bankruptcy and restructuring, and 2 circuits specialized in corporate law. When there is an appeal, this appeal will go to the specialized courts for such matters. So under the current administration of our organization, we were able to have a major accomplishment after a significant effort was undertaken. Many people believed that it would not be possible to do that regionally. However, on December 3rd, the very last days of our responsibility in this body, we have started these circuits. And someone told me, well, the textbooks will have to be changed after that. But that's a positive piece of news. We had Professor Marcato, Professor Pedati, and other who are major names in process law in Rio and Paraná and in other places. Those who are our professors and who are professors of many lawyers, they now have to teach that there are these 2 circuits and 2 regional fora, which are not the ones of São Paulo. So we have the first and the second regional fora, which is in the first administrative region of the Great São Paulo, and this is just for corporate law. So, Dr. Flavia, this is a bit different because you deal with bankruptcy, restructuring, and the whole corporate area, including industrial property, right? It's a huge territory that goes from Barueri, Arujá, and other cities and other municipalities, all the way to Guarulhos. Guarulhos is a major city, so you can picture the number of cases that we have there. It also includes the city of Osasco. I'm very sorry, Professor Manuel. I'm very sorry to interrupt you, but we are running late. And because this is electronic, we face a problem. We will have to end at a certain time. So I would like to ask you, please, to conclude. So, to conclude, this regional forum comprises the whole region known as the ABC. So it's the first administrative region of São Paulo. It's something new that we are conveying to all Brazilians, and the capitals will be in a position to do that. So I wanted to mention this specialization. Industrial property is thus centralized. It's a specialization covering a very large administrative region. And that's the experience that I wanted to tell you. Rio can do that easily, or other capitals such as Porto Alegre. So this is my message to you. I apologize for taking more time than was given to me, but I wanted to highlight how important this 15-year-old experience is. And certainly this experience can be useful to other areas. Certainly, we have all the decisions available, and we had the support of the Brazilian Bar Association. So, thank you. And I'm very sorry for taking so much time. But I do believe in specialization, especially when it comes to industrial property or intellectual property. My very sincere thanks, and I want now to hear my colleagues. And I apologize for having to leave this plenary earlier. It's an honor to be with Professor Flavia and Professor Abel Gomes. Thank you for your attention. Thank you so much, Dr. Manuel. It was really a pleasure to hear your trajectory in the Court of São Paulo, extremely fruitful and useful. You were one of the creators and the one who implemented this system. So thank you. And I'm very sorry to have to interrupt you, but it is my responsibility here. It's this is just a joke. I'm a lawyer, so being in a position to interrupt an appeals judge is really unusual for me. It's usually the other way around. Since you are my friend, I thought that I could joke about this. And I'm going to give the floor to Dr. Flavia Romano de Rezende. Thank you. I would like to say good morning to all of you. Jacques, thank you so much for your kind words. It is a great honor for me to be here in the ABPI Congress to learn with my brilliant colleagues and friends, Dr. Abel, Dr. Manuel, and I learned a lot about specialization. Certainly, this is a topic that is in our agenda in Rio de Janeiro, although we don't have such a positive experience here in Rio. And I'm going to approach a topic that is fundamental to the country as industrial property. I don't know if you can see my brief presentation. Dr. Jacques was worried because I started my presentation talking about positivism. And he said, well, if you start with positivism, it's going to take 3 hours. You're going to need 3 hours. No, this is not the case. In spite of these few slides, going back in time and in our philosophical history, I will only speak for 20 minutes. And I brought these first slides so as to address a theoretical landmark which is fundamental to binding precedents, and also talks about the thought of the end of the 20th century, beginning of the 21st century. At the end of the 20th century, positivism was exacerbated, confusing the concept of juridical norms and the law. There was also some confusion in terms of interpreting the law, in terms of that Kelsian mm, fundamental norm. I'm trying to simplify, and I know this is a topic that has received criticism in spite of the fact that it has given great contribution. And constitutions being mere political manifests that could not be invoked in terms of the rights. After the war, there was a reaffirmation of such rights in which in Brazil we had what was called the neo-constitutionalism. I'm simplifying, and Justice Barroso often talks about it, but there are others who mention that, as such as Dr. Miller. I'm bringing here the Brazilian perspective. And with neo-constitutionalism, it comes the emergency of certain principles that bring law closer to ethics and to morale. There's also the development of what we call the theory of interpretation. We leave behind concepts and formalist ideas, the precedent of interests, and we go to a jurisprudence of values in which we bring to the debate human rights. These new theories in this whole movement account for the fact that the judiciary takes a leading role, has more protagonism, together with social changes, increasing the number of conflicts, discredit of the executive power due to corruption scandal, and my colleague will be able to talk about it, massification of demands that get to the courts, and the backlog in our courts. Together with that, and as a way of trying to bring a cohesion to the upheld decisions, comes a legislative change that was absolutely necessary, beginning with the constitutional amendment number 3, which brings a binding effect to the decisions of the Supreme Court. And here I'm talking about the direct constitutionality suit and the laws such as the ones that I mentioned in my slide, which is law 9882. And there is also what we call the binding decision, the binding precedent in terms of our constitution. And I also mentioned in my slide law 11,672, and some well needed changes are introduced, including what deals with the decisions at the decisions taken by one judge only and the consequences of that. So, as a way of combining all this change comes the new civil code and this last law that I mentioned here, 13105, that becomes effective in March, and enshrines these constitutional principles that talk about the equity, effectiveness, security, and the systems of precedence.
Speaking of precedents, a more comprehensive way of looking at precedents, you have a more restrictive view of precedents and the horizontal scale. And then you have the binding precedent decisions. And then I am going to dwell on this in the next slides. So these would be a law norm rule to solve the merits of actions submitted to court. And then there's an article listing these decisions that should be observed by courts and judges around the country. If not, they may be considered insufficient or overruled. So there are some guarantees for protecting the rule of law. It is legal security, predictability, harmonization of decisions, and for industrial property, the certainty of a legal, reliable framework with known precedents for those people who are interested in investing in Brazil and those who invest in technology in Brazil, equity that changes the idea of every individual thinks differently, to harmonize decisions, and not less importantly, efficiency, forcing other court levels, making sure that a judge invest time in new actions, and also making sure that appeals are not going to be used just to delay decisions. So efficiency is very relevant. Delays would be a fourth factor. One needs to have legal security to foster investments. The other day, I heard on a live that the Brazilian PTO has organized a task force to examine patents for medication because of the pandemic. So the urgent remedies on banning the use of a trademark can have negative impact on when it comes to distinctiveness of a sign. If there's no provisional remedies, maybe compensation is not going to be enough to cover the losses related to a trademark losing its distinctiveness. So the backlog, there are decisions on a higher court level that construe that an injunction, when there is too much delay from the Brazilian PTO, this is very important to guarantee the rights of the patent or trademark holder. Here I'm bringing what Patricia Peroni talks about categories of operations with binding precedents. In addition to the theological and construction, which is part of civil law, and we're part of that, what we have inherited from common law and abroad is the same. The Obamacare Act is also a law that has been positivated into common law. So this is also happening abroad. So this is extremely relevant to understand, so that you understand the categories of operation with precedent decisions, so we can actually enforce them and guarantee the legal security. So she makes an interesting distinction. In the United States, the justices meet in closed doors. So one of them issues the opinion so that they protect a decision that was taken collectively in Brazil is different. It's a public opinion that's issued. So everything that's discussed among justices have to be put into precedence. She makes a distinction on what is discussed in the court is not essential for a concrete case, although it may be agreed by the majority of judges. And she also mentions marginal comments that are relevant but are not necessary for that judgment, and also distinction, which is the mechanism of distinction of the actual case and the case that originated the precedent. And if the precedent is not adopted and brought to the record, it is up to the judge to subside its decision by saying why it's not following the binding precedent. This is topic 950 from Justice Luis Felipe Salomão for special appeal on the screen, which is the only one on industrial property, talking about the absolute competence of the federal justice that has the participation of the Brazilian PTO. And that is why the court construed that the federal court is competent for the abstention of use of trademarks, as well as state competence for unfair competitions and other related issues, because they do not involve registration of the Brazilian PTO, and it is between individuals. This has been applied, and this is an issue that unfortunately we don't have enough time to talk about, but this is a very interesting issue because the issue that led to the repetition had something to do with unfair competition and misuse of a trademark, and it's running in a court that is dealing with an issue of patents. So this is an issue that we should be discussing more, having more attention and more debate about this topic. So this opinion is from Justice Belize as a rapporteur, and he says that it could suspend compensation lawsuits. So it's recognized the nullity of patent can be argued. You need to have an independent claim, but he affirms that the competence is under federal justice with the participation of the Brazilian PTO, making special mention to the special appeal I had just mentioned, including the topic 950. I'm just about to finish for our moderator's joy. I here bring some topics so that is food for thought. These have been discussed in case law. There has been a majority so that there's precedents to be established, and that would be great. And others that, given the non-consensus, more reflection from the judiciary so that we can actually establish precedents. Here is an appeal in appeal sphere talking about the competence when it comes to abstaining from the use of trademark legal actions. The Court of Appeals has understood that this is the competence from where the violation happened. So this issue is not a consensus because it's not related to a binding precedent. This is my last slide. These are topics that actually deserve more focus so that we have a more equitable and security, legal security for more investments. Um, uh, Compensation sometimes depends on the proof of losses. There has been a construction that the damage or the harm needs to be discussed for a consensus. We still have controversy around pipeline patents as for the amount of time of protection, a lapse of protection, and also nullity actions when it comes to the mailbox patents. And this is not subject to consensus yet. Other issue is the right of preference. Some decisions have ruled for priority after registration, or other courts that rule for that just before the registration is actually granted. So here, the need of technical proof for IP issues, this team could have been under consensus for superior courts. I don't know for trademarks and unfair competition. This is still under debate. But as for patents, I think this topic should have had consensus. So with this, I like to thank you for your invitation. I had to run so fast. I apologize for having spoken so fast, but I hope I have contributed for an interesting debate. Thank you so much. Judge Flavia, thank you so much. Would love to continue to talk about this the whole day. In fact, however, we have a time limit. Thank you so much. Your presentation will be available afterwards. Thank you so much. Hope we have